An African American man says he was shot in the face and waterboarded by white deputies in Jackson, Mississippi, causing him to be in the hospital for several weeks. What is going on in Mississippi? Let's talk about it. This is Criminal Justice Corner, where we discuss true crime stories. We give the real details surrounding what occurred, and just in case you find yourself in the same situation, we give you actionable advice and tips on how you can potentially get yourself out. I'm Dr. Jennifer Matthews, the host of the Criminal Justice Corner. I have 16 years of experience in the field of criminal justice and a doctoral degree in criminal justice. I am also an expert in video evidence. Today, I have with me a special guest, Sergeant Atha Hunt. Mr. Hunt is a police officer out of Chicago with extensive knowledge in the field of criminal justice, in addition to his hands on experience from being on the front line. Mr. Hunt, can you tell the listeners a little bit more about you?
Well, number one, please, as I tell people when I'm on duty all the time, please just Atha. Um, again, 23 years of law enforcement experience in Illinois with a combination of two police departments, with extensive backgrounds with respect to the application of search warrants, uh, DUI, DUI, and the various other felony offenses. In addition to creating and modeling a field training program for two police departments.
That is an extensive history. Thank you so much for being my special guest today.
Thank you.
Let's dive into this episode. Michael Jenkins and his friend Eddie Terrell Parker said on the night of January 24th, 2023, around 10 p.m., six White Rankin County deputies suddenly charged into their private residence without a warrant in the village of Braxton, where Parker was living, and proceeded to handcuff and brutally punch, kick, and beat them. They said the deputies violently shocked them repeatedly with stun guns over roughly 90 minutes. They also alleged that the deputies repeatedly said they were going to kill them. A witness to this incident described the officers participating in something of a taser contest, with Jenkins and Parker being the targets. At one point, they alleged the deputies forced them to lie on their backs as the deputies waterboarded them by pouring milk, alcohol, and water over their faces. Waterboarding is an interrogation technique usually regarded as a form of torture in which water is forced into a detainee's mouth and nose to induce the sensation of drowning. We know drowning is a process of experiencing respiratory impairment from submersion or immersion in liquid. I cannot imagine what these two men were feeling during this torture session. Atha, what is your take on what these two men are alleging?
Well, once you submitted to me this particular topic, I took the liberty of looking at the proffer that was offered by the attorney that is representing both of the gentlemen who were involved
Okay.
in fortunate circumstance. And when you read through some of the particular points, um, uh, and I'm just paraphrasing some things here. The deputies forcibly entered the residence, um, and according to eyewitness statements, all six of them ran into the house.
Right.
Uh, they entered the house. They immediately subdued both Parker and Jenkins,
Right.
and at that point, did neither of the individuals resist, run away,
Correct.
oppose the deputies in any way,
Correct.
or voluntarily or willfully resist the orders that were given by the deputies at the time?
Correct.
So, what's interesting to me? Let's start with what in Illinois we would call a tumultuous entry.
Correct.
Illinois law and police procedure is very specific when it comes to the use of search warrants. Now, of course, once search warrants are something that they have to be applied for by the state's attorney's office. And of course, in this state here, the application and the procedure for the obtaining and the execution of the search warrant are extremely similar. That
Right.
is have to offer up evidence to support that there's evidence of a criminal enterprise or a crime that's occurring within a particular vehicle, within a particular residence, or a particular place. Once I get that authorized by the state's attorney's office, and I get that also signed by a judge, then I have a certain window of time in order to exercise that warrant. Now,
Correct.
everything before they enter the residence sounds procedurally the way it's supposed to happen. The problem is once we enter the residence, um, once the deputies secured all of the individuals, remember, we have evidence that we're looking for that's contained within the residence itself.
Right.
And procedurally, in 20 plus years of law enforcement, the last thing that I want to do, um, once I've secured all of the occupants, I've made sure that it's safe for other officers or evidence technicians in order to enter the residence. The last thing I want is to hold the individuals at the residence in order to further interrogate them. And
Right.
of, these are post Miranda interrogations. Why? For the obvious reason. There's always the likelihood of the destruction of evidence. Even though a person might be handcuffed, they may kick something into a vent, kick something into a hole. There might be narcotics or the fruits of some other crime that they may attempt to hide. Why do I want to contaminate that scene any further than I have with the forceful entry of officers into the residence? So procedurally, I want to remove those individuals from the residence. I want to remove all of those individuals from the residence. Before transporting them and taking them to another facility for questioning. In Illinois, I have a duty immediately after securing the individuals at the very least. Illinois law is very specific in that I have to show the individuals the actual the actual search warrant itself. That is, I'm surrendering a copy to the parties involved, more specifically the homeowner. Now, it doesn't make a I couldn't find any literature or any narratives defining who the actual homeowner was, or if
Right.
the homeowner was served. But um, just at the beginning, just looking at this circumstance from the entry, a lot of things kind of, and again, I I, I want to certify that again. I'm speaking in terms of Illinois law and not law applicable to that particular state. And
Mhm.
uh, but it seems suspicious to me, um, and a clear violation of what us individuals in law enforcement would do procedurally after executing a search warrant. Once I've secured the residence, once I've secured the parties that are involved, uh, then um, I want to interrogate those individuals at another location uh, if it's going to rise to that occasion. Um, the record also makes mention of discovering a firearm, or that being the reason that one officer, that being the reason to justify the use of deadly force. Now, of course, I'm jumping ahead, significantly far ahead, but I wanted to point out some inconsistencies as a law enforcement professional. Um, there is These two individuals were ultimately charged. Mr. Michael Corey Jenkins, he was ultimately charged with possession of 2 to 10 grams of methamphetamine. In Illinois, that would be a class 4 felony, um, and then aggravated assault on a police officer. And based upon whether the officer suffered an injury or not, that would also be a felony. Um, his The other gentleman, Eddie Terrell Parker, he was only charged with possession of drug paraphernalia and disorderly conduct. Who Why is it that there were no other persons that were detailed uh, in either the proffer or detailed in any other articles that are immediately discoverable at the time? Why wasn't an individual charged with the unlawful possession of a weapon? In Illinois, anytime that you anytime that you have an individual who uses a weapon in the commission of a felony being resisting an officer, being the possession of a controlled substance with or without the intent to distribute that controlled substance. Anytime that you have a firearm that's being used and that firearm is being used in the commission of a felony, um, then that individual here would applicably be charged with the unlawful use of that weapon, the unlawful possession of that weapon. And so, just after reading it, and I read the entire statement from their representing attorney 11 times to prepare for this interview, there are just too many things here that just don't meet the litmus test of what is valid and what is clear as far as police procedure.
Now, you mentioned the interrogation tactics that you would use from an officer's standpoint. Now, as far as your interrogation tactics, would you use waterboarding?
Well, number one, the police are not permitted in the state of Illinois in order to use um, any type of methods that would violate a person's civil rights, that would knowingly or accidentally inflict harm upon an individual, that would cause an individual to be incapacitated. We're not permitted. This isn't the army. This isn't a conflict. Under no circumstances are we permitted to threaten someone with an act of violence, to threaten someone with bodily harm, or to cause violence or bodily harm to any person. No.
So that includes the punching, the kicking, the beating. That's not allowed here in Illinois.
In Illinois, that would be not only official misconduct, but that would also be an aggravated battery. Um, in that the individual, of course, I have to assume for officer safety reasons, subsequent to entering the house, they secured all individuals that were in that house. And once an individual is secured in handcuffs, that person is no longer considered a threat to you or any other officers.
And
Uh,
I definitely agree with that. That's exactly my understanding. Once they are detained and under control via handcuffs, they're no longer a threat. So the fact that these deputies allegedly did all of this extra tactics, the waterboarding, the beating, the kicking, that would be clear violation in my opinion.
it would be a violation definitely of Illinois law, and it would be a violation of three or four particular felonies. I mean, three or four particular federal laws. Yes, including unlawful detention, kidnapping. If I transfer those individuals from another location to another location from there, uh, based upon the preponderance of the evidence of this proffer, but absolutely, absolutely not. And when I say particular tactics with respect to interviewing, basic things. That is, there is no reason that I would logically and clearly interview one suspect in front of another suspect. I would
Absolutely.
uh, that gives the other suspect preparation in order to that gives the other suspect preparation for the questions that I might have for them. And of course, they're going to do their best to make their stories match. So I'm going to interview these individuals at a location by which I control. I control the lighting. I control the acoustics. I control uh, I control their access um, uh, to various resources. Um, it just doesn't make sense. And in addition, you touched on something else. Um, particularly in Illinois, after a subject is secure, the the number one thing that I have to attend to because they are in my custody, I have a duty to ensure. I have a duty to ensure that those individuals are healthy, without harm. Something in particular that I often do whenever I detain a suspect. Immediately after, particularly if there was a struggle, do you need any medical assistance? Are you okay? I'm checking for lacerations, bleeding, uh, anything that um, anything that might any plain view injuries that might necessitate any medical treatment. Because both pre and post the Illinois Safety Act, uh, that is a duty of all law enforcement professionals.
Now, both Jenkins and Parker alleged that the deputy stripped them naked, forced them to take a shower together, and attempted to use a sex toy on them during an hours long interrogation. Michael Jenkins has trouble speaking and eating because of his injuries. He alleges that one of the officers eventually put a gun in his mouth, pulling the trigger. The bullet went in through his mouth and came out of his ear, leaving him with a broken jaw and with wounds that require parts of his tongue to be sewn back together. His medical records that were obtained by the Associate Press show he was treated for a lacerated tongue and broken jaw and had to have multiple life saving surgeries to repair ruptured arteries. So, to me, this is additional signs of excessive force by these deputies.
In it, not only would I agree with that, everything that you detailed seems consistent. Both his statements and what was detailed on the medical records. Uh, all of these things seem consistent with the use of some type of weapon, um, particularly particularly a firearm. Only a firearm can cause such devastating damage to an individual, and this individual is extremely lucky in that area where the bullet where it was detailed that the bullet entered the individual's mouth.
Right,
I'm sorry, where the bullet was discharged into the individual's mouth. Um, uh, that bullet could have at any time struck either one of the arteries.
right,
And generally, as we say in law enforcement, a shot to the artery is typically a wound that a person does not come back from.
right.
Um, so yeah, these uh, and again, as we say in law enforcement, I try not to judge the actions of another officer, of course, because I wasn't there. But um, everything with the officer's purview of the circumstances versus the proffer that's offered by the attorney. Um, I would say that there's a lot of plain view evidence to support um, what these two gentlemen are stating with regard to this incident. Um, and then I have another problem. 90 minutes, 90 minutes inside of a residence
Right,
uh, with the application of the use of a taser,
right,
the application of the use of open hand or closed hand tactics
right.
uh, to individuals who, whether they're compliant or they're not compliant, um, uh, in all of that, all of that is to use the word excessive force is to almost be insulting.
I
Uh,
agree. And they
it
had witnesses. There were witnesses to this.
Yes, on absolutely, absolutely. Um, and the amalgam of the plain view evidence, right? In addition to the fact that again, and what I have a lot of trouble with is the fact that there were no persons that were charged with the unlawful use of a weapon. There are no persons. The other individual there should have also been charged with resisting if he was also a party to this circumstance. Um, there is no reason for any law enforcement official, or let's just be honest with each other. There's no reason for any sane individual who has passed a psychological exam, which is a standard for all law enforcement agencies in the state of Illinois. There's no reason in order to cause such a degree of harm to illegally and unlawfully uh, detain an individual to such a degree to inflict severe bodily harm on an individual and uh, over over some narcotics. over
Alleged narcotics, because we don't
over
know if they
alleged.
were planted at this point. If they're doing all of this, you can't tell me they didn't bring them narcotics in. You can't tell me that.
Absolutely, absolutely. And unfortunately, unlike in the state of Illinois, um, that state is not a state that requires yet the applicable use of body cameras.
And
Uh,
I have a huge problem with that. Huge. That's a
absolutely.
big deal to me. That's huge for me.
Well, any officer that has had expertise in the right training with the use of body cameras will swear by body cameras. Um, I can't tell you the number of complaints that I've received from individuals on the officers that I supervise, alleging excessive use of force, alleging inappropriate detention, alleging violations of various civil rights. And of course, with a body camera, it's it's the most wonderful thing in the world. I can
Right.
instantaneously use my phone while they're sitting there, and I can view the uploaded footage to verify whether or not there's any credibility to their story. Um, and when I tell you that complaints go down, complaints significantly drop with the use of body cameras. Um, I couldn't shout it and scream it to the world enough. Any
Right.
trained law enforcement official, any law enforcement personnel, um, they will grow to love a body camera to the degree that they will not leave the station without it. It's that
Right.
number one indefensible tool.
I definitely agree with that. And also, had there been body camera footage of this particular incident, these would not be allegations. We would know one way or another exactly what happened.
Absolutely, absolutely. I wholeheartedly agree with that.
So we know that these gentlemen were charged, but these some of these charges were dropped after these allegations came to light, and these gentlemen were going to sue. So that was interesting too. What do you think about that?
I would say, in all honesty, um, uh, before I would before I would blame the likelihood of a civil suit
Mm-hmm.
for the dropping of such charges, um, the state's attorney's office, when presented with any case, has a duty in order to review the applicable charges, review all applicable police reports, because ultimately, while the police charge offenses, the state's attorney's office or the prosecutor's office, they're the ones who are responsible for actually prosecuting the cases. And so I don't think there's a single state's attorney or assistant state's attorney um, who would look over any documentation that will just say that isn't completely clear, that the total elements of a particular crime doesn't necessarily exist. If there are problems and issues, particularly if we're going to run into a fruits of the poisonous trees type of circumstance where
Mm-hmm.
have a interrogation that was done without Miranda. There was a voluntary statement where the individual did allege to some particular crime, and it discovered that no, the officer failed to advise the individual of their rights. Well, then that means that all of that testimony that the person gave is now no longer can be held as evidence against them. So
Mm-hmm.
I think before the suit, at a as a matter of due diligence within that respective state's attorney's office, I think they looked at some circumstances and surmised that, well, there are some things that we may be able to charge. There are some things that in this circumstance there there's insufficient evidence in order to prove beyond a reasonable doubt that this person or that person, either one of them, committed the various crimes that the police are alleging that they did.
I agree with that. And then also, according to the attorney representing Jenkins, no deputy has been disciplined or terminated by Rankin County, and all the deputies are still roaming the public at large. And it was further learned that many of the officers involved in this incident were a part of the sheriff's office special response team. an elite police unit that draws similar comparisons to the Scorpion unit involved in the beating and death of Tyree Nichols. I thought that was very interesting.
Um, how can I say this uh, um, without making things just utterly too obvious? Um, during any investigation, right,
Yeah.
into police misconduct, classically, and again, I'm speaking for agencies in the state of Illinois. Once there is an allegation of misconduct against an officer,
Mm-hmm.
and once there is any part of that allegation that may be more likely than not to be sustained,
Okay.
or if it's a serious allegation into a felony offense or an offense which would discredit the department, generally that officer is removed from their assigned official duties.
Right.
Uh,
And in this case, they weren't.
yeah, yeah. And I don't want to use the word racketeering. That's the wrong word to use. But
Okay.
um I you, how can I put this? Um if there is a pattern of practice, not to paraphrase what Mr. Jenkins' attorney is very clear on. If there's a pattern of practice in the police department of um, trying to disguise,
Okay.
uh, minimize, trying
Mm-hmm.
to remove from, I use the word discoverable, remove from discoverable eyes police misconduct,
Okay.
then hey, as we say in law enforcement, unaddressed behavior is always accepted behavior.
Exactly.
And in this circumstance, I think, and again, remember, um, all persons are innocent until proven guilty. But um, the this circumstance is more than troublesome, to say the least.
I agree with that. And then speaking of pattern, Jenkins isn't the only black man claiming Mississippi police in Rankin County shoved a gun in their mouth. Carvis Johnson filed a federal lawsuit in 2020 after he says a deputy placed a gun in his mouth during a 2019 drug bust. And at the time of this incident, Mississippi sheriff's deputies were already under investigation for possible civil rights violations. So this is an ongoing problem. And there's no way that Jenkins and Parker could have possibly known about these other incidents unless they were all friends. And I just find that highly unlikely.
Well, what is more of a concern for the sheriff's department in total, that is that um, just be you can be a head of a law enforcement organization, right? Well,
Yes.
there's this term called vicarious liability. And that is to say that if you know that there are persons who are subordinate to you that are committing violations of the rule of law, they're committing violations of the federal law, they're committing violations of your applicable policy and procedures, and you engage in a pattern of conduct that either knowingly permits this activity to go on unchecked,
Right.
uh, it's almost tantamount to authorizing under the color of your authority,
Right.
uh, in order to go out there and uh, commit the horrible abuses and the horrible violations of rights that we so happen that are just now coming to light today. So um, the what the concern really falls on the executive head of the sheriff's office and all or any of those individuals that those persons report to. The question is, how much did they know about their activities? Were the prior instances where these individuals may have, and I only say may have because, again, we live in a society that guilt has to be proven. But
Correct.
um, um, if 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 persons who were in a supervisory position on up to the executive head of the police administration for that county sheriff's department uh, failed to properly investigate prior allegations of misconduct, um, if they did whatever they could in order to hide or obscure from public view um, uh, uh, a a dangerous and profound history when it comes to these particular officers or others involved. That means that if these circumstances are substantiated in either a criminal court against the officers by way of indictments, um, or through the Department of Justice's investigation into the matter, um, these individuals won't be the only ones who will be held accountable.
And I think that is very good because I always say that you can't do anything by yourself. There has to be some complicity along the lines. So
Absolutely.
let's say the deputies are doing this. There has to be a supervisor that knows what's going on, and then that supervisor has to know what's going on. They can't just be operating in this fashion and nobody knows anything. So I definitely think that if they're doing it, the whole line should crumble, if you will.
Well, I mean, that's the way the law is meant to work. That's absolutely the reason. And it's a reason why in a lot of the women's self-defense classes and a lot of the classes that I give to juveniles on interaction with police, um, there are some things that you can do as a citizen that you would never think of that could protect you against um, such mistreatment, or at least permanently memorialize evidence, let's say, that could be used in a criminal court and civil court if a normal citizen were to have their rights violated or were to happen to fall victim to police misconduct.
Yes. Now, as a result of the allegations by Parker and Jenkins, the FBI has launched a federal civil rights investigation. A spokesperson for the Mississippi Bureau of Investigation said the state agency also is investigating the shooting that is alleged by Jenkins as well. So I think these investigations are very necessary because if anything is true that has been alleged by these men, the deputies involved should be terminated and held accountable for their actions on that horrific night because we know already that their employer is not holding them accountable.
Everything that you're saying is more than reasonable. Unfortunately, everything that you're saying is more than reasonable.
Now, one other thing I would like to do is give our listeners some takeaways. So, my first takeaway is nobody has the right to deny you of your civil rights and liberties. Those men were inside their own home, which was Parker's home at the time, when the deputies came charging in. So, there is no reason why they couldn't enter the residence and have a civil conversation with the two men that they allegedly were trying to be in there without the warrant. They could have knocked on the door. They didn't even try that. They just kicked the door in. So they immediately resulted to violence when they could have just knocked and tried to talk to the men instead of just kicking the door in and, torturing these men. So if anything in these allegations are true, these men should be held accountable and there should be some justice for Jenkins and Parker. And already know that they're going to have a long road to recovery when it should not have occurred to begin with.
Absolutely. And a long road to recovery is an understatement. You've got an
Yeah.
individual who is dealing with some physical injuries that uh, who knows how long it will take for that individual to get back to full strength and health. In addition, for all of us in law enforcement, it's just another it's just another person whose perception of police has significantly changed. Our
Absolutely.
our primary duty as police, as law enforcement personnel, are peace officers. That's
Right.
why state of Illinois, when you look to define in the statutes under Chapter 720, under Chapter 725, Chapter 720 is the Illinois Code of Criminal Procedure. Chapter 725 is the Illinois Code of it is the Law Enforcement Procedure, and of course, Chapter 625 is the Illinois Vehicle Code. Um, uh, it is very difficult to find the word police officer, but
Right.
you can find over and over and over again the word being used, peace officer, because my primary duty is to keep the peace. My primary
Absolutely.
is a public servant. And this individual, who is extremely suffering beyond all words, which I have to describe, of course, um, he will permanently, his perception permanently will be marred. And this will be another individual who will, of course, hopefully after getting back to full health and strength, um, will tell other individuals about his experience, and then it will taint other individuals. It has a likelihood of tainting other individuals' perception toward law enforcement. um, when, as I like to say, the public servant, the right officer, comes along trying to do the job that they're meant to do, to help someone, to advocate for those who can't advocate for themselves. So it's a tremendous injustice on a lot of levels here.
I agree. And it's unfortunate that we had to even have this discussion today, but I love to make people aware of the injustices that are going on in the world so that they can try and protect themselves in case it happens to them in the future.
Absolutely, absolutely.
If
And
I, okay, go
oh,
ahead.
I'm
I'm sorry.
sorry. I apologize. Go ahead.
No, no, you go ahead.
If I may, I wanted to at least add a few tips.
Sure.
Uh,
Absolutely.
any citizen should know. Number one, um, I want all of the listeners to know that you have the deadliest weapon that you may have in your entire arsenal with you, and you carry it day by day, and you would never know it exists. It's called a cell phone. And what Illinois law says, and a lot of states are reciprocal of this law, that there is no reasonable expectation of privacy in the public view. That means if you're on a traffic stop, if an officer stops you on the street, even if you're in front of your own residence, um, there is nothing wrong before being stopped by the officer, before having the interaction with the officer, to simply turn on your cell phone and turn it on video and just put it in your pocket. Have it where the camera can observe everything that's going on. And if it can't, it's definitely going to record any volume. Why is that so important? Because remember, a lot of people don't know that your pictures and video include something called metadata. This metadata is what us in law enforcement use in order to um, take a cell phone, perhaps, and say definitively before a jury that this cell phone, to the exclusion of any other cell phones, was at a particular location, or that this picture was taken or this video was taken by this cell phone. So if I'm going to mistreat you, if I'm going to say some things that I shouldn't say, why should you worry? You have your independent witness, just like I'm going to have my body camera, and we can record all of this together.
Right.
Don't be afraid to use those cell phones. And remember, you don't have to tell the officer that that cell phone is on. You don't. Just like, because in Illinois the law is very clear. There is no reasonable expectation of privacy in the public view. And remember, I'm the one who stopped you. So, what do I care about being recorded? What do I care if I'm following the rules, if I'm following my applicable policy and procedure? Then everything's okay. So, just like you would see something interesting to post to TikTok, or see something strange out in the street, in your interactions, keep that information in your cell phone. One. Two, it never hurts to ask for a supervisor. If you feel nervous, if you feel scared, um, you have a right to ask for a supervisor, uh, and for that supervisor to have a reasonable amount of time in order to get to the scene. Why is that so important? Because the more eyes and ears that you have on a circumstance, the better it is going to be for you anyway. Um, if the officer is doing one thing you feel uncomfortable with or getting too close to you, okay, let that supervisor come over so that they can explain the entirety of the circumstances to you. Those things are always helpful, and you have a right to do that. With traffic stops, you do not have to pull over immediately if you suspect or feel that, hey, the person behind me isn't a law enforcement officer and I'm scared. You can hit your hazard lights, slowly drive to a place that's well lit. If you really feel nervous, you can call 911. Say, I think I'm being pulled over. I'm going to my nearest police station and I just want someone to know. 911 dispatch is going to route you to the closest location that your cell phone pings a tower to. They're going to notify whatever officer is behind you that, hey, there's a person who's on 911. They're identifying that you're trying to stop them. And so it de-escalates a lot of things before the officer gets a chance to have contact with you. If they have that information, then it's more of a conversation than, hey, get out the car, why are you doing here, etc. And the most important thing that I can tell any individual is, remember, be calm, be respectful. Of course, you don't have to like anybody. It's kind of upsetting thing if you're trying to rush to work or do anything else and you're being stopped by that officer at the time. But you'll be surprised at how just being kind, being respectful, mitigates those circumstances and keeps things as an ease. Remember, by law, the only thing that you have to do is to surrender an identification and a reasonable reason why you are in a particular place or why you're doing a particular thing. Beyond that, um, you have a Fifth Amendment right against self incrimination. So just because I don't advise you of your rights, you can tell the officer, hey, at this time, officer, I respectfully would like to remain silent. You can do whatever procedurally you have to do, but I've surrendered my name and date of birth, or I've surrendered my identification to you. I've told you why I'm here. And at this time, I just don't feel comfortable making any further statements. And if there are further statements to be made, I respectfully would wish to have my lawyer present. You'll be surprised how that cuts all the nonsense. Because if I'm really there for the purpose that I'm there for, then everything's going to go the way it's supposed to. There's going to be no one dragged out of any cars, assaulted, sexually assaulted, beaten to death, handcuffed, shot in the mouth. That doesn't happen. Uh, so those are some of the um, while this particular topic here that we're discussing leaves me with more than pause. I don't even understand how these deputies are even out still with a job. But these are some of the things that you can do to protect yourself.
Those are some very helpful tips, and I know our listeners definitely appreciate that. Atha, I appreciate you for being my special guest today.
Thank you so much, there, Miss Matthews, Dr. Matthews. It's a pleasure to be here.
You can find me, your host, Dr. Jennifer Matthews, on Instagram at Dr. Jennifer Matthews and the podcast at Criminal Justice Corner. Please comment, like, subscribe, and share. Tell a friend to tell a friend about Criminal Justice Corner. I will see you next time on Criminal Justice Corner. New episodes are posted every Wednesday. Thank you for listening.